Thank you. I request Honorable Member SCRC, C. Abhishek Murali sir, for a formal welcome address.
A very good afternoon and good evening to one and all present here. Honorable Registrar of Companies, CA, Shri A. Sehar Ponraj sir, our Joint Director, S. Meenakshi ma'am, who has also been a close associate of both my father and now luckily me as well. Sehar Ponraj sir is a Registrar of Companies, and as a matter of pride, he is also a chartered accountant and one of our fraternity. In fact, he had already addressed our members a couple of months before and gave a very, very wonderful address with a very interactive session where he clarified a lot of doubts that members had pertaining to ROC matters and MCA matters. In fact, when he was posted earlier in Ernakulam, he continued to be of our support to our institute, then traveling across Kerala, addressing many workshops. So he is a great patron to our CA Institute and a matter of pride for us. Thank you so much, sir, for taking time out of your busy schedule, and ma'am for joining us today on this very, very important program. The program today is on ease of doing business, and it's a very, very apt topic given the fact that today, if you read the newspaper, you would have found India has jumped 14 places in ease of doing business, up to 63rd rank. It's a great achievement for our country. In fact, as chartered accountants, we would have seen earlier ROC and MCA were lines which were neglected by almost all companies and all directors. People never used to file their annual return with the ROC, and directors also, they never used to file their compliance requirements with the ROC. Still nothing was done, people were taking it for granted. But in the last few years, the government has done a phenomenal job, and people like the chief guests and guests of honor here present today, they have played a very critical role in ensuring compliance and cracking down on things like shell companies, etc., which was really found out they had a very, very key role to play as part of the MCA and finding out shell companies who are these directors who are appointed without any background. You ask some directors who they are, you will find in the shell companies it will be drivers, maids, all these people will be directors of companies who are not qualified to actually handle the finances of the company, signing the checkbook, etc. And all of this has come out in MCA, which means MCA has suddenly taken a certain dominance, a certain spotlight and importance in our society. And as auditors, we are also thankful because it has given us a new line of business also. Because ensuring that people are complying, we get a new line where we can monetize. And this has been some very, very important developments which have happened. And our speakers here today, they'll take us through very, very important topics. And if time permits, they will also take some questions that you may have pertaining to MCA or ROC matters. Now, before I give the dais officially over to our speakers today, I'd like to introduce our speakers. First, I will introduce our Registrar of Companies, CA Sehar Ponraj sir, ICLS, Registrar of Companies, Tamil Nadu and Andaman and Nicobar Islands. He is a BCom, an ACA and ACS, a direct recruit through the UPSC and joined the Indian Audit and Account Service in 1987. He worked as an Assistant Auditor Officer in the office of the AG Commercial Auditor in Mumbai and then Tamil Nadu. He is a direct recruit through the UPSC and joined the Indian Company Law Service in the March of 2003. Prior to the present post, he has worked under different capacities in the ministry. He was the AROC in Kanpur, the DROC in Bangalore, and the ROC in Kerala. His native place is Uddangudi in Tamil Nadu, and in fact, he was awarded the best officer in implementing the digitization of documents in the MCA and the project in the office of ROC Kanpur. Of course, his accolades are really endless. The biggest thing about him is, despite his lofty position and despite his achievements, he is a person who is very, very kind, very, very down to earth, and he enjoys interaction. And one thing that goes as a personal mark of respect from both me and our institution is, sir is someone, if you enter his office and say that you are a chartered accountant, he immediately does his best to help us, and that is really special. Thank you, sir, being a chartered accountant. It's a great matter of pride for us. I would now like to just honor our chief guest with a small memento and token of our love and affection. I request CA Asif to please come on stage and hand over a token for our memento, and I will be presenting the shawl to our chief guest. I will now introduce our guest of honor and second speaker, Joint Director S. Meenakshi. She is an MCom, MLM, Master in Labour Management, and she was the first rank holder in the course, and Masters of Law from the University of Madras. She entered into government service at the age of 22 years in the Ministry of Social Empowerment, Shastri Bhavan, New Delhi. She was transferred to Chennai and joined the Ministry of Corporate Affairs in the year 1990 and was selected as ICLS Officer of the Year in the year 2001 and posted as Assistant Registrar of Companies in ROC Chennai. She was transferred and posted as Assistant Director in the Office of the Regional Director of the Southern Region in Chennai in the year 2007 and was then subsequently promoted and posted as the Deputy Registrar of Companies in ROC Chennai in 2010. She has been transferred since to the Central Registration Centre in Gurgaon as a Deputy Registrar in 2016 and then transferred and posted as Deputy Director in the Office of the Regional Director of the South Eastern Region in Hyderabad. She was promoted as a Joint Director in the year 2017 and she has recently come back to Chennai and is in Shastri Bhavan in Chennai, and she is completing 29 years of service in the Ministry of Corporate Affairs in September 2019. As I already stated, ma'am was known to us for a very long time, and she, like our chief guest, is also a very down-to-earth and kind person, and listening to her is always a pleasure. She is a very, very positive person and a very, very bright smile she has. Thank you so much, ma'am, for joining us today, and as a token of our love and affection, we'd like to present you with a memento and a shawl. May I request C.A. Lakshmi in the back to please present our speaker with a shawl and a memento. With this, I would like to conclude my welcome address. And now I request Shri C.A. Sehar Ponraj sir, ROC, Tamil Nadu, Andaman and Nicobar Islands, to take the podium and give us a rousing address as he always does. Welcome, sir. Please give him a huge round of applause.
Regional Council Member Abhishek Murali, and all the distinguished members, friends, and Joint Director Madam Meenakshi. Very good evening all of you. It's a very hard time. It's a Diwali time we have arranged this meeting. Anyway, it is as per the Ministry's instruction, we have to arrange this meeting, and I requested our institute and they obliged. Thank you, sir, for arranging this meeting. I think last month we had a conference with our secretary, and the message was that we should approach all the stakeholders, professional institutes frequently, arranging such meetings to find out the ground realities, any issues are there. So we should facilitate the measures for the smooth functioning with the ministry as an interface like ministry and the stakeholders. The ROC and the RD should realize that is the message. So with that in mind, we requested, and this meeting is arranged. And future also we'll have meetings so that we can have a better understanding in to enable us to discharge our functions effectively so that the stakeholders are satisfied. Today's topic is ease of doing business. I will not take much of your time. Madam will give a presentation, a detailed presentation. And as you all know, yesterday that results were published, India's ranking, it is 63rd among the 190 countries. Previously, last year it was 77, so we have improved 14 positions. It's really a great achievement, and still we have to move forward to achieve the 50 rank target. That was the target of the government. And ministry also taking a lot of measures and to improve the ranking. As you all are aware, this World Bank is making this survey, and they are assessing these ranking parameters. There are 10 parameters. I'll just rush through. You all know that, but anyway, I'll just rush through. There are 10 parameters. That is starting a business, dealing with construction permits, getting electricity, registering property, getting credit, protecting minority investors, paying taxes, trading across borders, enforcing contracts, resolving insolvency. But the Ministry of Corporate Affairs is related to only 3 parameters. That is protecting minority rights, resolving insolvency, and starting a business. In starting business, that area, India, this ministry has initiated a lot of measures. I would like to highlight certain initiatives that was initiatives taken between June to May, where that is the period fixed for deciding these ranking parameters. During those period, what are the initiatives taken accordingly, what are the improvements made, then the ranking is done. As you know, Sehar is established, that is in 16 established, and to centralize the registration process, to speed up the registration process, to align with the best global practices. There were issues in CRC initially, but now I think a lot of things improved. Still, Ministry also taking a lot of efforts to further improve the functioning of CRC. That will definitely help the stakeholders. Then launching of spice forms, integrated MCA system with CBDT for the issue of PAN and TAN. Then a new form, that is a run form for reserving a name. Even without DSC also, you can apply a name and reserve a name for incorporating company. Then the LLP also, instead of LLP1, there is a run LLP, and LLP2, there is a fill form. This also now centralized. It was with the ROC, now it has gone to CRC as a centralized service. And while notification dated 6/3/2019, the zero capital norm introduced for companies having capital up to 15 lakhs. That is another initiative taken by the ministry. And in spice farm, instead of giving affidavit, declaration is enough. Previously, affidavit has to be given, now declaration is enough. Then this spice farm, again agile farm that was introduced to integrate EPFO, ESIC and GST. This in one go you will get all the registration. This is one of the initiative taken by the ministry. And in name already also there are rules are simplified to get the name. There are illustrations to avoid the ambiguity in getting a name. And now Section 8 companies licensing also now gone to Central Registration Center. Now for ROC only we have approving only the e-forms. And of course we are concentrating on nowadays in enforcement functions like inquiry, inspection. That is one of the major area we are concentrating on that. So now I will ask Madam to start the PPT. She will explain in detail what are the areas of serving business and what are improvements done by ministry. Then after that, if you want to have any queries, we will be happy to answer. Thank you.
Thank you so much, sir, for a very brief but incisive analysis of what ease of doing business is. We always used to think why India is ranked higher, what is the basis, but you have enlightened us, and once you gave the categories, it's very obvious to us why we have done so well in moving up the rankings. Thank you, sir. And now we will have our joint director, Srimati S. Meenakshi Madam, who is the joint director of the office of the regional director based in Chennai. So she will be taking us through a PowerPoint presentation on the same topic. Thank you, ma'am. We welcome you to the dais. Please give a huge round of applause.
Respected Mr. Abhishek Murali, Regional Council Member, Registrar of Companies, and the respected professions who are present here. Good evening to everybody. It was the intention of the ministry to conduct various seminars and workshops before. In fact, they wanted to have this seminar and workshop before 24/10/2019. Because yesterday was the survey conducted and the results were out on ease of doing business conducted by the World Bank. But anyway, just we are delayed by one day because the ministry wanted to explain to the stakeholders that what are all the initiatives taken by the Ministry of Corporate Affairs. So we had conducted the same set of workshop and seminar in CS Institute and Cost Accountant Institute. And that government has done, that is Ministry of Corporate Affairs has done lot of things, and still they are doing, because they wanted to minimize the procedures so that stakeholders should not feel any hurdle to upload the forms to get the companies incorporated. So in all the possible ways. So I wanted to tell you what are the steps taken, measures taken by the government for ease of doing business. So I just put you in by way of PowerPoint. See, this type of newspaper cuttings you must have seen now and then in the newspapers, that how what is the steps taken by the government by various forms. So we must have seen this type of news cuttings. So now we should understand why do we talk about ease of doing business today. Because it was ministry's intention that we should have participated in the survey on 24th. That is through the stakeholders, so that who all should participate in the survey, and they should give the feedback. So that once the feedback, positive feedback goes up, our ranking also will improve. That was the intention. But anyway, we are conducting this today, and yesterday that results were out. So World Bank has conducted a survey on ease of doing business, which concluded on 24th and released the that DBR report. So what the report says? Before that, just we should know what is that. Why do we do the business? Because in the earlier economic growth of trajectory, we have seen there was a gap between the in the sectoral contributions, because we were purely dependent on the agriculture, and we changed. We were never been in the industrial economy in those days, but however now we have grown a lot. So there were a lot of gap between the GDP contribution and the population ratio, and slowly it improved, and we have a better business now, more business opportunities. As a result, we have a higher growth, and we get lot of opportunities for jobs and good standard of living, and we have higher development and improved in happiness index. So this was the background of business. Then what this World Bank says. So it says that an aggregate figure that includes different parameters which defines the ease of doing business. So this index was published by World Bank, and it was always aiming at a distance to frontiers. That is, we always aim at the people who have grown a lot in the business. So if we compare to the higher end, top is New Zealand. They are in the topmost of that index, and we were improved a lot from when we compare to 2014 to 2019. We have our ranking has improved from 134 to 63 as per the yesterday's result, and still our Prime Minister wanted to reach the position of 50. That we will reach soon because of various efforts taken by different government departments. So these are all the 10 parameters, out of which 3 parameters pertains to Ministry of Corporate Affairs. Resolving insolvency, starting a business, protecting minority investors. Of course, the remaining parameters are very important. You know, as a chartered accountant, you must be knowing what are all the changes happened in the parameter of paying taxes and construction permits, getting electricity, trading across borders, then enforcing contracts, getting credit, registering property. So these are all the parameters given by the World Bank. Then now if we see about the recent changes, India performed better in the 6 of 10 parameters used for the ranking. So they are very good in starting a business, dealing with construction, trading across the border, resolving and paying taxes, getting, out of which 2 we are in good, that is starting a business and resolving insolvency. And this time the performance fell little, there was a fall in the registration of properties as per the recent study. And India is one of the 10 economies that implemented most reforms in doing the business. And we are seeing a continued progress. We are trying to reach to the top, and a lot of efforts are taken. And we have reached 14 places above. Now we are in 63rd rank. So out of 190 countries. So in the parameters, if you see, on getting credit, protecting minority interest and enforcing contracts. When comparing to the last year, we are not that much improved. We are just maintaining. There is no much changes. Out of which this minority of protecting the minority interest, ministry is may now, after seeing this result, some more changes we may face. And if you take enforcing contracts, there was no much progress in India because it has remained in 163rd place in the out of 190. See here it is, the World Bank has made an assessment in the enforcing contracts, in which it is what the World Bank says is, in India the time and they are saying that the time and cost involved for a business entity in resolving its commercial disputes at lower courts, if it takes more time, then enforcing contracts we may not reach to the higher end. So Government of India is taking various efforts like improving the professional resources in the courts, and they are planning to introduce All India Judicial Service like IAS and IPS. Now they are planning to introduce All India Judicial Service. Then e-court services, there are a lot of you know very well that what are all the e-court services they have done. Then out of court settlement, that is mediation and conciliation. Even in another Companies Act, that mediation and conciliation section in rule has come, but it can be still more enforced, because I feel that though we have the section and rules, I feel it is not 100% utilized, because I have seen every year lot of professionals from all the field. They are, that is from chartered accountants, CS and cost accountants, advocates. They are applying for the mediation and conciliation, and the panel is prepared by the regional director in each region, because this power is delegated to the regional director. So we prepare the panel, and the panel is ready and it is placed in the website. But I feel it is not utilized. It can be effectively used, because what is the role of the mediators and conciliators, how they can be best utilized, that can be that needs some improvement. But anyway, we have been giving lot of feedback to the ministry that how to utilize the panel more effectively. Maybe if that is used, still more our time consumption in the courts, in NCLT and in other places, it will come down. So if it happens, naturally this enforcing contract, our ranking would surely improve in the next survey. But there is a tremendous improvement in the areas of dealing with construction permits, trading across borders, because the procedures have come down in the trading, because it is not taking nowadays much time. Because though we are not directly concerned, I will just focus on MCA efforts, just I am highlighting you. But if you see the last year's survey, we had a lot of, we had grown, our ranking had improved a lot. If you take this business, starting a business, we were in 156th ranking. We had improved to 137. The same way resolving insolvency, from 137 we improved to 108. Trading across the borders, 146 to 80. Construction permits from 181 to 52. So there is a continuous progress. There has never been a downfall, or sometimes there is a stagnation. Now, to understand the ease of doing business, we should know what is government process re-engineering. It is called GPR, because it has got some link with ease of doing business. So what are all the various government process re-engineering? These are all the sample examples, because initially we were having passport services in a centralized form. It was decentralized. So as a result, now getting passport is an easy. Online reservation of tickets, implementation of CNG, metro rail, getting salary through banks, that's MCA 21. These are all part of GPR. So this GPR is done by a separate government department. Now this, what are all the role of the government to make everywhere easy, lot of efforts are taken. These are all some samples. So now ministry wanted to mainly inform the stakeholders that what are all the effort taken by them from 1st May 2000, as Sir told, from 1st May 2019 to 1/5/2019. Because during this period, government has taken lot of reforms. I am talking about MCA. Now I wanted to tell you, for ease of doing business, not only commencement of business, it is also about conducting the business and the cessation of the business. Everywhere we need to have a simpler procedure. So these are all the three areas where government has taken lot of effort. But in this, if you see, regarding starting of business, there were lot of efforts. Conducting also, will know what is the changes have made, and in cessation, exiting also, there are a lot of things have happened. Now I wanted to, though ministry has told that 1/5/2019 was that period from which they wanted to tell, just for your better understanding, I wanted to tell from the day of commencement of the company's incorporation rules, there were a lot of steps taken by the MCA. Because there are only in this rules there are 20 notifications. Recently that 21st notification has come. So if we go through that, then we will read, because we read and very frequently we read, and the next day when new notification comes, we just ignore the earlier one. But if you, just for your information, I am just highlighting you, not in detail, because we have been doing the incorporation procedure manually. That time, what type of problem we faced, how much time it was taking, you know very well, because I have been also, done the job manually and we have shifted. So if you see that rule 36, it was introduced in May 2013, that integrated process of incorporation, all the forms were clubbed into a single form, but it was manual, and that time you have to fill the form manually and then scan it and then upload it. It was the procedure, but it was done away. They have omitted it in January 2017, but when it was introduced, it was a very major change. While in the ROC office, we felt so happy because the incorporation has come down, procedure has come down. But later on they omitted because some more improvement has happened. Again they introduced rule 24 of the company's incorporation rule. It was in May 2015, because they had done away with that is declaration at the time of commencement of business. That was introduced and then they have removed it. But later on some more change had come. Then in January 2016, they started the Central Registration Center. That notification came in January 16, wherein only the reservation of name was done by the Central Registration Center. Then followed by, they amended the incorporation certificate, because the address portion will change. Earlier our respective ROC's address were coming. That time they changed the address. Then on 27/7/16, if you see that notification, there were so many amendments, but the important amendment was, if there is any prosecution is pending, the shifting of registered office will not happen. So unless you close all the prosecutions, shifting from one place to other place will not happen. In the same way, conversion of unlimited liability company into limited liability company by shares and guarantee. This was introduced in July 2016. Then in October 2016, they introduced the SPICE form. See, I'm happy to share that I also got an opportunity to work under in the Central Registration Center. Because when initially January 2016 they commenced with the incorporation, name availability. Then in March 2016 they commenced the incorporation. See, from sitting from here and we are talking, but when I worked in CRC, I found what are all the difficulties government has faced, because that internet speed, who will process the form. Even today, only the forms are processed by the company secretaries, qualified company secretaries. There are around 145 company secretaries are sitting and processing the form. It is doing wonderful, and now present ROC Mr. S.V. Kumar, he is not even keeping any single paper. Friday means he will clear all the incorporation documents. So I can say morning people apply and they get the registration in the evening, provided everything is perfect. So I feel after working there, I feel that it is doing very well. As a result, now ROCs are able to concentrate on other nature of work. As sir told, now we are able to concentrate on section 206 inquiry, then inspections, and then apart from that, lot of other prosecution matters, because government has changed the mind of the even officials of ROC. Now we think we can do a lot better, so that better enforcement can be made. So in 1/10/2016 they introduced the form SPICE. This is an excellent form, you must be seeing, because all the informations are put in the single form. And after that, rule 39 was introduced in the same notification, conversion of a company limited by guarantee into shares. Then they introduced EMOA, AOA, and again, because the SPICE form is undergoing lot of changes based on the various comments received from the stakeholders. Because there is a separate team who is keeping a note of the requirement, because when we introduce any form, there will be here and there some issues will come, but whenever any feedback comes, they are keeping on amending. Even in September 2019, very recently, they changed the SPICE form. So the first amendment had happened in December 2016. So as a result, again there was a change in the incorporation certificate format. So in July 2017, they introduced a very important notification, because here they gave a very good clarity when a company is shifting from one place to another. Earlier, each ROCs were following their own methodology. Each will ask for some 10 documents, other ROC will not ask. So there was no uniformity. Now, through this July 2017 notification, that they standardize the format, so 100% they follow the same procedure. So it became a common rule common procedure everywhere. Again in January 18, this Rule 9, that is the reservation of name, again got a second amendment. On March 2018, this run form was introduced. In this run form, no digital signature is required. And in July 18, so they were getting the affidavit and declaration from the first subscribers. Now affidavit is ruled out. Even if today, if you see the website, that running message will be going. Affidavit is not required, only declaration is sufficient. Because of the affidavit means you have to get it in stamp paper and other thing. Now the declaration by first subscribers and directors only. That is, they made it into single. Then again December 2018, this section 2 subsection 41, change of financial year. It was aligned with NCLT. Because of various other issues, it was this power is now given to the regional directors. So this section 241 is dealt by the regional director. If you see, as on date, I think yesterday I received only one application, last application, only that is pending with me. Otherwise, we just clear the applications on day-to-day basis. Nothing is pending except yesterday. I am telling my SR statistics, Southern Region statistics, nothing is pending. So as a result, see why these are all falling under incorporation rules. These are all forming part, because you cannot find anywhere pending. Maybe in bigger ROCs, one few may be there, but we clear it on day-to-day basis. And in February 2019, this Rule 25A was introduced. This is very important rule, because this active form was introduced in February 19. So if you don't file the active, the companies are not filing the active form, then these forms will not be through. So if you see, all these forms are very important forms. Unless you file the active form, if you see the amalgamation and demerger report, people will be coming and filing, but if they don't file active form, this form you cannot upload. Then in March 2019, they introduced a very important change, that Rule 38.2 was amended, where up to 15 lakhs, capital, authorized capital, you need not pay any filing fee. It is free. So these are all the effort I can say government has taken. So now, even yesterday, one person inquired me, what is the fee for? I said, so up to 15 lakh, you can register without any fee. They felt very happy, because even many are not aware the changes happened in the ministry. Then in March 2019, this one more form was introduced, that agile form. If you file after the incorporation is over, if you file the agile form, all these numbers you will get attested: GST number, EPFO number and ESIC number. This is one of the important changes. And when they introduced the active form, everybody requested for extension, so they gave the extension in April 2019. And in May 2019, they simplified the incorporation rules. Name availability guidelines. If you read this May 2019 name availability guidelines, you will never get any doubt. You can check whether what the name you are opting for is available or not. And if you follow strictly that rules, it is very, very useful, because they have given it with a different type of illustrations. Then in June 2019, they again amended further for Section 8 companies. There were both application for license and incorporation for Section 8 company. Both you can submit it in CRC. Earlier it was incorporation was done by CRC and license was given by the respective ROCs. Now they have clubbed it with CRC. As a result, time consumption, even it is going very quicker and smoother. And in August 2019, they amended the RD1 form and RDGNL5. This is also falling under incorporation rule. And in finally, in latest September 2019, that SPICE form was amended. See, if you see this instruction kit, the instruction kit itself is 37 pages. This is the last change. And recently, I think just a few days back, again one more changes has happened. That is very in detail. So these are all the changes has happened in incorporation rules. So as a result of this, there is a smooth happening, is a smooth, there is smooth in the incorporation procedure. As a result, the commencement is happening very quickly. So I feel still government is planning to do some more changes. Based on this, maybe based on this yesterday's report, some changes may happen. And in the incorporation rules, if you see LLP and Section 8 companies, that there was no provision to convert the society trust into a Section 8 company. But now they have introduced this. Now your trust and society can be converted into a Section 8 company. And rule Section 366 was again amended, wherein earlier the Part 9 companies, in the 1956 Act, there was a chapter called the Part 9, wherein the partnership firms were converted into a company. Now they have made it very simplifier, because even with 2 partners, you can now convert the partnership firm into a company. Earlier, if you were not having the minimum number of partners, you have to increase the number of partners to 7, and then you have to come for Part 9 conversion, because in Part 9, 7 subscribers were mandatory. But now they have done away with that. Even with the 2 partners, you can register convert the partnership firm into a company. And in the same way, just like run form, here for getting the name availability for LLP, they have introduced run LLP. And even for incorporation, just like SPICE, here there is a form called Philip form. And applicant can apply for DIN in the Philip form at the time of incorporation of LLP. So this process had simplified a lot. Now if we take conduct of business, because we need ease of doing business even in the conducting of business, there are lot of changes. Lot of changes have happened in almost all the rules. But latest changes I want to bring it to your knowledge, because this decriminalization of offences has happened. 13 offences have been decriminalized. By the way, you need not, that is, there won't be any prosecution will be filed before the courts for all the committing of any offences. So all will be now dealt by the ROC by way of adjudication procedure. So it can be ROC will find the violation and he can adjudicate that offence. Otherwise, you yourself can voluntarily go and submit an application. Sir, this offence has happened in the company, kindly adjudicate. So there is a procedure for adjudication which ROC will comply, and he will impose the penalty. You have to pay the penalty. If you feel that the penalty is more, you can make an appeal to the regional director, who has got the power either to reduce, depends upon the situation. If you don't pay that penalty in time, then ROC can again file a prosecution. If that happens, you have, that is, just for information, if that happens, in the court, they will impose one fine. You have to make good that offence. For that, you have to pay the fees and additional fee, apart from that penalty to the ROC. So 3 expenses will arise. So to avoid that, comply with that, otherwise pay the penalty and close the offence. You no need to go to the court. ROC will not file any prosecution. And then this is also one of the important changes in the conduct of business, because from NCLT these issues compounding, conversion and financial year, that is compounding of offences, earlier it was with NCLT, now they have increased the limit to 25 lakhs and the offences are compounded by the regional director. As central government, here it is power is delegated to the regional director. Then conversion, converting the public company into a private company. Earlier it was with NCLT, now it has given to the regional director. In the same way, section 2 subsection 41, change of financial year. So the by which a lot of time is, reduced, time consumption has reduced, and it is done by the RD level. And but here 13 violations are brought under adjudication. However, still more government is planning to make more offences under decriminalization, for which a separate committee is formed and they are under the process of bringing more offences under the adjudication. Also, if you see under the oppression and mismanagement, the central government is now empowered to initiate case against unfit and improper person and refer the same to NCLT. So this is the power given to the central government, this to us. Then in case the NCLT concludes that such person is not fit and proper, then such person can be debarred from holding an office of director. Earlier in 56 Act this provision was there, now it has come. Then he or she shall not be entitled to pay any compensation for the loss of office. So I feel by this type of changes brought in by the MCA, there are a lot more are there, but if we read day by day the notification circulars, rules amendment brought in by the MCA, we will understand in a better way how it is going in a smoother. If you take exiting also we need to have a easy way of exiting. So in this, now in the yesterday's report, resolving insolvency, India has shown a jump of 56 places, endorsing the successful implementation of IPC. So this is one of the major change by which the companies can be closed very easily. If you see the importance of IBC code, see it has taken away the sick company, rehabilitation of sick companies chapter old provisions, and now they have brought in part 2 of chapter 20, wherein voluntary winding up of the companies are happening through the IBC code. Then it has shifted from debtor in possession to creditor in control. Then moratorium period is fixed, wherein within 180 days the procedure should be completed, dealt by subject matter experts. So the IRPs are there, so they handle the procedure very easily. Then there is a board called IBB board, which is handling the administration and governance. Then information utilities. See, there is a information, it's not depository, it is a repository where all the information is available with in this IBB board. Suppose a bank, if they want to give a loan, they can refer to the repository. They will know about the entire history of the company. So by way of this IBC, this information utility has come. So if we go to the site and see, you can know about the entire history of the company. Then scope to address. So here in this in IBC code, even individuals, partnerships, companies, LLPs, limited liability entities, everything, they can file a case and they can get it resolved. See here, if you see, repetition. If you see debtor in possession and creditor in control, there now you know very well that there is something happening, like whether NCLT and Enforcement Directorate. Enforcement Directorate also, they are taking the assets of the company for their violations under that act. But now there is some dispute, something is going on wherein who will have the power, control, whether NCLT or ED, that government is taking, and we will come to know about that soon. Then, so because of IBC, there is a resolution and revival of businesses happening quickly, and it reduces the burden on judiciary. It is NCLT and DRT. Then there is a fall in NPA burden of the banks. Earlier the recovery rate was only 72%. I mean, now it is 72%, whereas it was only 27% in 2018. So because of this, that recovery rate has improved. In the same way, time taken for insolvency improved to 1.6 years comparing to 4.3 years. So exiting is happening quickly, and there is a special focus to MSME and real estate. Because of this IBC, now even if we have paid any advances to the home for home buying, if it is not paid, then we can go to NCLT and file a case and get a remedy. So recently, home buyers is also included as a financial creditor. So these are all the important changes, and I can say advantages of having the IBC. Just I have given a small brief because our aim is talking about ease of doing business. So I feel the government has taken many efforts for starting a business, for conducting the business, and for exiting the business. And Ministry has recently, in September 2019, they have constituted a separate committee called Company Law Committee. Our MCA secretary is heading that committee for ease of doing business only. So now they are planning to have more offences under decriminalization. They want to decriminalize more offences, and they want to make it more effective, that LLP Act. Because in our LLP Act there are some shortfalls, because even any investigation is ordered, even the term inspection is not available under LLP Act. So either inquiry or investigation. So inspection is missing. So there are a lot of gaps that they wanted to fill it up. So everything is for ease of doing business. That's all. So I just gave you an overall picture. There are a lot of things to know more. So we should keep on watching our notification circulars, changes in the rules, changes in the amendments. Then we'll have a better knowledge. Thank you very much.
Thank you so much, ma'am, for a very wonderful session. I think it's important, we appreciate why that session will be very important to us. Not just knowing what has happened, but why it is important going forward is because we have the recent amendments that the finance minister announced, where there were significant tax cuts, down up to 15% for companies. So I think going forward, it's already come into effect now, and going forward in the next few months, as Chartered Accountants, we will have many new people approaching us to establish new companies. It might be existing people, it might be new people, it might be investors from abroad. So ma'am has actually gone through a wonderful history of what are all the changes, and I was very enlightened by this fact, because now when the clients come to us, you'll be able to explain to them what the process is, what the changes are, how it is more beneficial for maybe a foreign company that's setting up in India. You'll be able to explain what are the changes, what are the activities and actions taken by the government and the ministry. And it's clearly very supportive to have in India, to hear that morning you apply for registration of a company and by evening it is approved is really something amazing. And even at a time when I qualified as a CA, I didn't expect that would ever happen. So I'm very, very happy and thankful that you're playing such a key role in doing this. Thank you so much, ma'am, for such a wonderful address and taking us through all those aspects. Since sir and ma'am are here for a short time, some questions in the audience that you may have, maybe not just pertaining to what was covered today, but any other matters in MCA or any challenges you may have, you can feel free to ask our guests.
Good evening. I have three questions actually.
probably you can put inside, through your internal communication so that it can be implemented shortly. See, we are unable to answer few questions when foreign subscribers or foreign directors are trying to open a company in India. For example, recently we have allowed to have AGM inside India, provided it is approved by all the shareholders. So when the shareholders are only foreigners or two corporates from China or from Japan, they are asking why not we conduct the AGM also in our place. See, when it is a private limited company, when the whole stakeholders are not in India, why there is a small change, like when EGM you can have it in foreign country if it is a wholly owned subsidiary company. Why not AGM? This question even I don't have a logical answer to respond to that questions. And second, recently I have incorporated a company with one China company and another German company as the shareholders. The two companies appointed two foreign nationals as directors. They don't want to keep any Indian name in their MOA or AOA even as first subscriber or as first director. They got DSC. In the SPICE form I am going to ask for DIN, but their DSC I am not able to use. Because of that, I have included one local director. Because for role checking, I need either DIN or I need PAN. So only when they have some income to get into income tax department, they need PAN. Otherwise, they have no need of getting the PAN. So department has to think some alternate mechanism for this. And for this type of companies, we are using not EMOA because a lot of notarization and everything is coming. And this company has sent me a AOA and MOA in English and Chinese because they don't know English, so they have both versions and they insisted me to upload it. Since we are using only INC 32 form, 6 MB it is not possible. And if we compress, I am getting a resubmission not readable. So when a company is using only single form, that 6 MB can be given little higher size, or they should give some other means to upload a large chunk of documents. Because in this case, everything is notarized. INC 9, water declaration, everything is notarized. So it was very, very difficult. And third difficulty what we face is, very rarely, at least once in a month, the mail which states about the PAN and TAN of the company is not reaching the company's mail ID. And if they want the PAN card and if they go to this next building, they are telling we cannot give, you go to ROC. ROC will say it is from income tax department. So for this also there should be a window where we can get addressed in case if you want to get the PAN card, where to go, whether to ROC or to income tax.
Sir, I feel that
You have to address this to Joint Secretary Policy and Joint Secretary E-Governance. If you write this, if you send a mail to both of them, because role of both the Joint Secretaries are involved, I feel 100% they will take it into consideration and they will do the needful, because they expect the professionals to send a mail. There is a separate team, maybe they will not resolve it immediately, but surely they will take it seriously. Because when there is an opportunity comes, they will make that required change. Because that's what I have understood. Because when I was in CRC, I have received so many mails. So if it is, if we can resolve that, we will do that. Otherwise, if it is pertaining to policy and e-governance, we will direct them, revert that mail to them. So they are taking care. So that's what you can. I can give you the mail ID. You just, when you come to my office, I will give you the mail ID.
Thank you.
Thank you.
No, regarding this AGM out of India, anyway, it is regular amendment.
Yes.
As per rule, it is usually within India. Okay, this is a policy matter, we escalate.
Oh, thank you, sir.
This will be, I also agree with you, because for every reason the partnership, why you should already come from this country to India to have a lot of measures, media companies, so many measures are, technology improved measures are there. At that point anyway, we will escalate, because it needs an amendment. So without that, that cannot be done. Other one is regarding this name, I am not able to understand, because foreign name is not accepted in India. See, I don't
Role
understand.
check, either the DSC holder should have DIN or PAN. Otherwise, I cannot do the role.
No, but you will have DIN, no? So he is only shareholder.
No, I am applying the DIN through the incorporation form.
Right. See, the two foreigners,
Yeah.
foreign names, that DIN will can be applied, no?
No, I am
If you apply
applying
in the
through
SPICE
I am applying through the SPICE form.
Right.
So at the time of application, I have only DSE. I don't have stamp.
Acha, you know, the DIN, you have to use such. They don't have DIN at the time
Yes.
of the
Yes, I can apply and get the DIN up to 3% in the incorporation form itself.
So inevitably you have to bring somebody with a DIN and then
Yeah, only for the purpose of that, with lot of hesitation, they agreed to include another person.
yeah, this also will escalate for consideration. They can relax. And another one, what is that? 670, yes, that is even SCMA also the same issue was there. That also will. These are all.
No, when we are using 3 forms, we have 18 MB size. Each I can use 6 MB. But when foreign subscribers are
But
there,
addendum they can't use it. Addendum.
they will put only resubmission, then we will ignore
No.
some.
See, one attachment 6 MB maximum capacity.
No, one form.
One form, including addendum. So it is coming more than 6 MB.
Yes. So when foreign
Previously it was 2 MB, it was enhanced to 6 MB.
No. When China and Germany, their main document will be in their language, then they will do a translation and then notarization. So that takes. If I compress, it is not readable. That is the resubmission problem. When immediately they will say we are not able to read.
You could add charge for that. I mean, if a person wants to add the extra MB, maybe you provide the charges, you can fees for additional.
So this all your concerns will be escalated because I was already escalated your 2 points which you raised in the same way. Regarding that DSC, instead of DSC, it is e-signing. That already escalated. Today only I have got RD. That another is signing MGT7 and AOC 4. Other one, what is that? You raised 2 issues.
That too only. Now the synchronization between the income tax and the MCA is there because audit appointment and all. We are informing in 3CD. If IT return form itself, we are informing the auditor appointed details. Again, we want ADT 1 in MCA. Our cost auditor report also, we are informing in the income tax return details. So again, why a businessman has to inform in ADT 1, Form 23C and all. This, if possible, we can combine it. We can avoid this duplication.
That is a company requirement.
Yeah, I understand, but as from a business point of view,
Integration means then both can be combined.
No,
Both
the ease of doing
the
business point of
regulators
view.
can be combined. No, that may not be practically possible.
no, but for the ease of doing business point of view, we are simply duplicating the work. We are informing in
You know, I am telling my view, but
Yeah.
I will escalate your concern. I am telling my view because certain things
I
are
understand
possible.
that.
Now I have to again go to my office. Now I am completing my 3rd drive, strike off. Today is we are completing. We are around 4,000 companies still. The 3rd drive. Still they are not complying the requirement. Any more questions?
Any more questions?
Sir, what are the advantages of converting?
Converting?
Converting society or trust into Section 8 company?
I don't feel any major advantage. You see, Section 825 also it's a special vehicle as non-profit. From tax angle, I don't know how to. Otherwise, only from tax angle.
Society and trust is more comfortable.
I'll keep the road convert. The option is there. You
What
will,
is a specific advantage under the companies?
see, company side, see, Section 25 companies have privileges. There are certain exemptions availed by Section 25 companies.
Transparency is more when it is a corporate.
From an operational point of view, foreign investors, etc., donators, they may prefer a company because it is easier for them to verify the data with the MCA rather than the society registrar. Because there is no transparency there. Who will you know who are the trustees, etc. You have to go there in person and then only you will be able to find out. At least with the MCA, it is easier for you to get an understanding about the background of the company. Anybody can go pay and view. So that comfort is there. So maybe from a donation and a foreign investor point of view, it might be beneficial. But as sir says,
But you see now, actually now, I am adjudicating this Section 21 companies for non-compliance. Around 140 companies, they have never filed any returns. That's the fact. Now I have issued notices and now they are coming. Yes, our intention either you continue or get out. Two options. So now they are all that Sangam, this Sangam, Tamil Sangam, all big shots actually. Doctors, complaints. Then I said, if you want to continue, continue. We are 7-8 years, they are not filing any returns. So now I said, you file the return, latest one, surrender license. Convert, then automatically you become a private or limited company. Then go for strike off. Surrender license, then close the business if you want to close. If you want to continue, comply. Or file all the returns. But anyway, this is only I started this process. Let us see what will happen. Section 25 companies, it is a area even now for, it's a burden for us. Yes, we can't be very harsh also. These are mostly they leave you donations, subsidies and other things. It's not for earning revenue. Basically they want to do some service, social service or something.
Whether, as you said, you are in the third drive of strike-off. Whether the department is taking any action on the strike-off company who have not moved for restoration or something. So there is a lot of rumors coming that magistrate court is sending notices to directors of that.
Once strike-off means there is a question of further prosecution.
For that period, which was pending something.
No, if the complaint was filed before strike-off, that cases will go.
No, not like complaint. Whether the department is again taking action against the directors to for the pending annual returns.
I am talking about the third drive. Third drive, I am telling you the process. After this process, we will complete today and we will send the list to even DFS and IDA for freezing accounts. It's a process. Okay. Then, after restoration, if company comes, then defreezing is possible.
Yeah, my question is not.
And disqualification will also follow. Other than that, beyond that, I don't find any further action from our side. Because disqualification also will come. Yes, we cannot stop it because already we have started to. So it is not fair. No, we have to continue the process. And regarding this one, INC 23 and DR12 that clash, now it is resolved. There is a notification. Now even there is no signatory. At least limited brand company too can be added. Now we are adding from the back end. Now by filing DR12 that can be solved.
Waiting for the amendment in the forms.
But I think the rules are amended, but the forms are not amended. So now they will do it and it will be easy for them. So that this lengthy process of ROC, back and updation and this can be avoided.
okay, thank you. Yes. So, once again, I'd like to thank our chief guest and guest of honor for taking their time out of their very busy schedule. In fact, Sehar sir and madam are going back to office and to complete, as he already said, he has strike-off work he has, plus a lot of other work also. So he has come in between, spent 2 hours with us despite it being Deepavali day. So thank you so much, sir and ma'am, for being here and the wonderful interaction also with our members. Please give them a huge round of applause. With this, I'd like to thank the members who are present here today, the staff and
National anthem.
the staff and also the Ministry of Corporate Affairs for giving us this opportunity to interact. In fact, they were very particular that we should have it, and we would have got a bigger attendance if it was not for the Deepavali day, and also the closure of tax audits is also nearby, so a double whammy. Otherwise, it would have been, the hall would have been full for such a wonderful session. And thank you so much, sir and ma'am, once again. And we will close with we request everybody to please stand for the national anthem.